Good evening and welcome to the January 9th meeting of the Civil Service Commission. May we have roll call, please?
Commissioner Manukian.
Here.
Commissioner Gazarian.
Here.
Commissioner Gantis.
Here.
Commissioner Hatamian.
Here.
Chair Devine.
Here. We're going to break from our agenda here and take one item out of turn, item number 7. I'll ask if you'll read that in, please.
Class specification for approval, Police Civilian Division Commander.
Mr. Doyle.
Mr. Chair, members of the Commission, this item is a class specification for a newly developed class position that was approved by the City Council in the previous year. The position is called Police Civilian Division Commander. It's a non-sworn command level position. This item was brought before the Commission at its December 12th meeting. The Commission had some concerns about some of the essential functions relating to this position, mainly those relating to the duty of having this individual act as the police chief in some capacity, as well as assuming command at certain incidents. Staff has gone back with the police chief and softened up those areas a bit, and we're here to present this again to make to see if those changes are sufficient to the Commission and offering to grant its approval. Also, last time this item was brought before the Commission, we didn't have the benefit of having Chief DePompa here to articulate his vision for this particular position. So at that, we are presenting this back to the Commission, and Mr. Chair, I'll leave it to you to determine the next steps.
Okay, I'll open it up for any comments from commissioners. Pardon me?
I just have one inquiry.
Okay.
Thank you. With respect to the modifications, aside from the two modifications wherein may act for the Chief of Police in his or her absence has been deleted, and in its place may be assigned to represent the Chief of Police in his or her absence. And then the second one contained under the section that is titled Ability 2, the assumption of control of crime scenes, disasters, or other appropriate situations has been deleted and instead has been modified to be maybe assigned to assume policy level command of an incident during an emergency or unusual circumstance. Outside of these two, have there been any other changes I have not noticed?
Commissioner Gazarian, to my knowledge, no. Those
Okay.
are the two changes, and as you can see from your draft specification, those are lined out and underlined. So
Very well. I have no questions of the Chief. Thank you for being here. I am satisfied with those modifications.
Mr. Manukian.
Yes, Chief, first, before I want to make a quick comment, first I wanted to, on behalf of this Commission, thank the men and women of the Glendale Police Department for, again, doing what you guys do for when we have incidents like home invasion robberies, and when you guys get there, to be able to support this community and catch these guys, my hat's off to you. That's all I can say. And it starts from the leadership all the way down for everyone. Thank you for everything that you guys do.
Well, thank you very much, Commissioner Manukian. We appreciate that. And our men and women do go beyond and above the call of duty and what they do on a day in and day out basis.
Hopefully, I would never have to call at 5 a.m. And report a home invasion robbery, but I know if that day comes, at least someone's going to show up at my door.
If you do, we'll get there quickly.
Thank you. And with that, I'm ready to vote on it after Mr. Gantis.
Mr. Gantis.
Well, as you know, I was the most vocal of the ones opposing the last iteration of this, and I continue to be opposed to this iteration. My concerns are twofold. I don't have a problem with the position, obviously. That's a necessary position. I think it's an appropriate way to do this. My concern is if, in fact, we have an incident, and I believe these job descriptions allow this non-sworn person to assume some sort of responsibility or a policy level, decision-making policy level, at the scene of that incident. And without having, my 13 years on this commission, and in listening to many things, is that the sworn officers are a special breed. They have post training. They have training that this particular person, looking at the qualifications, is not going to have. I don't see the need for it. We have obviously a police chief. I think, as I read the article, we're going to make one of the captain's positions an assistant chief, and we'll still have 2 captain's positions. We have 4 sworn people that could make these decisions. I just don't think that that's an appropriate thing to have happen. That's from my, and I think it leaves open some issues concerning liability, because if in fact one were to assume that a situation where there is a disaster, shall we say, and I don't mean to rattle cages, but let's assume a Sandy Hook situation came up here and we had this person there. We know there's going to be lawsuits arising from it, and without having a sworn person that's assuming that policy making, I'd be concerned that this could leave open our ability to properly act and leave open issues that may or may not be proven in court, but at least are issues that I think are abated, if you will, with sworn personnel. Secondly, from the standpoint of the disciplinary proceedings that I've listened to, and again, if somebody were to be disciplined for inappropriate activity at an incident, not any incident. Let's just assume they're going to an arrest warrant, and this person is the policy level decision maker, and there's a sergeant that goes to an arrest warrant, and everything goes heads up, and that sergeant is disciplined. I assure you that as part of the discipline, it's going to be going up the thing, and this wasn't done right, and we weren't given the proper orders, and this was a person that wasn't trained to do that. I just don't think that from the policy standpoint, having a non-sworn personnel given this kind of possibility to assume policy level command of an incident, I just don't think that that's an appropriate thing to do. I just don't. I think it creates a problem, and I can't support that. I can support the position. I can support him filling in your place, Chief, at non-incident situations, non-emergency public functions. I don't have a problem with that. I just have a problem with leaving open the possibility that he's going to assume some sort of control, policy level command at an incident. So as it's written, I cannot support this.
Okay. Before we have the chief comment on that, I think I'll have Mr. Atamian weigh in and let us know his thoughts on it.
Thank you, Chief, for being here tonight. I just have one question on the chart that was provided. I would say it's after page 3. And then it shows the commander position as being under the Administrative Services Division. Are there any sworn members that will be under the commander, the civilian position, or can we assume that it's going to be professional staff that report?
Commissioner Hatamian, may I address Mr. Chair? This particular construction of this division will predominantly be non-sworn professional staff. However, there will be, as designed now, one sworn lieutenant within that division. And that sworn lieutenant will oversee the traffic and air support functions.
Okay. And so if that lieutenant has any issues that arise that may require sworn input, would they be reporting to the civilian commander, or are they going to be going to the Field Services Division or any one of the other sworn divisions to get input?
Well, on a day in and day out administrative setting, the civilian commander in charge of that division would be that lieutenant's direct report. However, depending on the nature of the incident, a field emergency or some kind of investigation or incident, they may be reporting to any one of the division commanders. It just depends on who by chance is on call or responds to that particular incident. So it could vary.
Well, I want to thank you again for being here. I appreciate the changes, and I feel as if the changes that were made will fit the position of a civilian commander, so long as, I would say, some of the concerns that Mr. Gant has brought up are to have a chain of command with sworn that will directly, if you have a sworn lieutenant and they come up with it, if there's certain issues that come up during the day where it requires the input of a sworn captain based on their experience, so long as they go to the captain who's sworn so they can get direct input from their experience and their training, I would see that that would be recommended from our, right, Mr. Gantis, is that what?
No. My concern is that he is given in here, under the new changed law, may be assigned to assume policy-level command of an incident during an emergency or unusual circumstance. This gives him, as part of his job description, in my mind, the ability to be assigned the command of an incident, an emergency incident, and that he would be the policy decision maker. And I just don't, he or she, excuse me. And oh, by the way, Chief, thank you for being here. Thank you for all that you've done, and Happy New Year. I know I'm being a bit aggressive, but I do still respect enormously your work.
We appreciate your thoughts and concerns and feedback, Mr.
But that's my concern, Commissioner Italian.
Mr. Chair, my understanding is a bit different than Mr.
Okay, well,
Commissioner.
let me interrupt right here. We've heard from the four of you. I do have some comments, but I'd like to hear the chiefs. If you'd share your thoughts with us on Mr. Gantis's concerns.
Absolutely, I'd love to. Thank you, Mr. Chair. And again, we do appreciate Commissioner Gantis's observations and concerns. Let me tell you that this is a very high-level management position. As police captain that oversees a division, this civilian division commander would be at that same second tier in the organization. But when we look at how these individuals function, especially at the scene of a crime or an emergency, it doesn't change our operation at all, in that there will be operational sworn commanders that will be responding to and handling any scene that we deal with. That's how we operate. That's how we respond. But at the division command level, that captain or this, in this case, a civilian division commander, would operate at a policy level. And that means to ensure that proper notifications are made to city staff, to the city manager, to ensure that policy levels or policy issues are being addressed, to ensure that our legal and liability issues are being attended to. But this is not anything unusual in law enforcement. This is a very, very common practice in law enforcement. Many agencies employ civilian division commanders. In fact, we recently hired a civilian division commander away from Beverly Hills to function as one of our bureau administrators currently. And she was highly respected, extremely capable, and thought on from that organization's perspective on an equal footing to any of their captains. And probably, truth be told, could have easily acted on behalf of the chief in an acting role. So this isn't uncommon for the profession. And the way it's structured, it doesn't mean that there's not going to be sworn operational commanders in charge of a scene, carrying out the operational side of our service provision. But we always have a captain or a division command level ensuring that we're meeting the policy aspects of any given situation. So it's not unusual. It's not unusual for municipal government either. And let me give you an example, by the way, how we operate our emergency operations center here in the city. If we have a major situation, for example, the Metrolink train disaster, the police chief and fire chief were responsible for handling the operation, but the actual incident commander on that situation was a city manager, a civilian. Now, that civilian city manager does not know necessarily the ins and outs and specifics of running the police and fire emergency operations, but they had the police chief and the fire chief there to carry out that function, and the city manager was there as a final source of policy on behalf of the city. So that structure, that practice is much the same here that we're doing internally within the department, albeit on a smaller scale. But it is a very well accepted practice in the organization, especially now, given the economic recession of the last 4 years and unprecedented budget cuts to agencies across the state of California. This has become a very common practice because, quite frankly, it allows us to fill a very high-level management position at a substantially lower cost than what we'd pay for a sworn officer. Now, ideally, what I'd like to do, I'd like to be adding, I'd like a full assistant chief, I'd like 4 sworn captains, I'd like to have my 12 sworn lieutenants back that I had at one point in time, but that's not the economic reality. The reality is I have the same sworn staffing that I had, or that the police department had in 1952. Not anymore. We have the exact same sworn staffing. When you look at our entire organizational composition, a little over 5% of our employees are at the management level. That is extremely lean in terms of management personnel. What does that mean? That means I have to get the most out of all my managers, whether they're sworn or non-sworn. And we have 4 very capable, non-sworn civilian administrators that run major 24/7 functions of the department that are highly capable, that clearly understand policy and how we operate, and it would be more than capable to step into this role and do it very successfully.
Isn't the jail run by a civilian?
Absolutely. We have our jail. We have our 911 communications center. We have our business office and evidence and property. We have our records function. But regardless, while I think we have very, very capable people inside, you can rest assured we're not going to put somebody into a position like this unless I have the absolute confidence that they're going to be able to perform the functions as we've detailed to you here. And I would ask for your trust and faith in me as the police chief to ensure that we're going to put the right people in the right places, and we're going to ensure the appropriate service delivery to this community. I've been here 35 years, and this is my hometown. This is where I'm invested. We would never, ever jeopardize the safety of this community or the efficient functioning of the department in any regard. So I just pass that on to you to give you some sense of comfort in how we proceed here.
Do you have a comment?
Yeah, the comment that I have is very simple. I mean, I appreciate Commissioner Gantis' concern, but I agree. I have the full, utmost confidence that our chief and our city manager is not going to put someone in this position that's going to be questionable. And with that, I'm ready for
Okay, I'd like to make
I'm sorry.
one comment, then we'll
Sure.
take it. Okay, go ahead with your remark.
I was going to ask you, Chief, how common it is. You already said it is common in other departments. With respect to the other issue, I understood policy level command to mean policy level command vis-a-vis implementation of already existing in-place policy versus policy making, which I believe my colleague Commissioner Gantis is appropriately concerned about. In as much as substantially lower cost is the benefit to the civilian commander joining the second tier, so long as it is without compromising public safety based on your representations, I'm satisfied. Thank you for your time.
Okay. Any other comments? Yeah, I do have one comment. First of all, I did share Commissioner Gantis' concern about this that one position or that one duty, and the chief very eloquently explained how it's going to work and really convinced me that it's not a problem, and I'm prepared to support it. The only additional comment I would make is that with the new wording under Ability 2, where it went from assume or effectively or foster to may be assigned, that really, in my opinion, threw it into a category of being an essential function rather than a Ability 2. So I would only recommend or suggest that they move that where it says may be assigned to assume policy level command of an incident, so on. I think that would more appropriately fit under essential functions, because that becomes a function just like all of the other ones described there.
Certainly.
I'll ask Ms. Varpetian if you have a comment on that.
Well, only that maybe what we would do is delete the first 4 words and have it begin assume policy level command. Ability to assume policy level command of an incident during an emergency rather than may be assigned to assume.
Is that what you wanted, Commissioner?
Okay, either way is fine with me.
Then
Actually, I could
I would-
support the latter language.
Okay.
I could support, that's just an ability, that's one of their functions.
Okay.
then I would make a motion with the amended.
I could support that.
Okay. Is there a
Amended
sec-
as a function, Commissioner Gantis?
Well,
Now, leave it as ability to,
Ability to.
and but,
because it's not saying they are, it's just they have the ability to.
but,
Yeah.
and delete may be assumed to, and just start with, or may be assigned
Two.
to,
Second.
and just start with assume policy level command.
Okay.
Thank you for the suggestion, Ms.
Then
Varpetian.
my motion as amended.
Is there a second?
Second.
Roll call?
Commissioner Manukian,
Yes.
Commissioner Gazarian,
Yes.
Commissioner Gantis,
Yes.
Commissioner Hatamian,
Yes.
Chair Devine.
Yes. Thank you, Chief. We appreciate all your good work and your coming and seeing us.
And thank you for taking this item out of order. I apologize for disrupting your
understand.
schedule,
Not a
but I have
problem.
another community function I have to.
Go say hello to the Glendale Bar.
I will. That's
Sorry,
where
I'm
we're at.
I've got to miss it, sorry.
And congratulations to Captain Rock on his new assignment. We look forward to working with you in the future.
What's his assignment? I didn't hear this.
He's taking over Todd Stokes' position in Administrative Services.
Oh.
And City Manager Scott Ocho, Merry Christmas, Happy New Year. Thank you for
Yes, sir.
joining us.
Thanks for being here.
Okay, we'll get back on the regular agenda. We'll have the minutes. Is there any comments, any?
We have new minutes.
Okay, we have a set of new minutes. There was one change made on item number 17. They just reworded that a little bit. And if there's no objection, we'll accept the minutes as amended.
And Mr. Chair, if I could say for the record, copies of the amended minutes are at the back of the room as well for all to see.
Move to approve.
Okay, is there a
Well, wait a
second?
minute, whoa.
No?
The language in there, it says reinstate to their former positions, only one employee.
Well, no, I questioned that, and in order not to disclose the gender of the employee, whether it's he or she or his.
Its former position. There is two
It?
people. I mean, it's just this, to the former position or something, it just is not grammatically.
Mr. Chair, members of the Commission, we agree
Mr.
with you.
Lasher.
Grammatically, this is not ideal, but to have stated he or she would have disclosed the gender of the
No, I understand
individual,
that, yeah.
and we need to safeguard that. So if
Or we, I'm sorry for interruption, forgive me, Mr. Doyle. Or we could say public employee to the public employee's former position, if you want to be grammatically correct.
We have way too
I have no
many
problem
attorneys-
either way.
We have way too many attorneys on this board.
Reinstate the public employee to the public employee's former position.
Okay, do we have a motion to approve the minutes as
Yes.
amended by Commissioner Gazarian?
Professor Gantis, yes, I move that.
Okay,
way.
move.
Yeah.
Do I hear a second from?
Oh,
Mr.
yes, second.
Okay. We have unanimous consent.
We do.
Okay. Next item, please.
Recruitment and examination report.
Mr. Doyle.
Mr. Chair, this is just a note and file item, trying to keep the Commission apprised of recruitment activity. We're barely down to about 1 1/4 pages of recruitments. You'll note the director actually has a recruitment. It's been a long time, but that reflects the executive level position of Chief Information Officer that we're currently addressing. But all the other recruitment activity is listed here: opening dates, closing dates, dates for exams, and such. If you have any questions about this report, I'd be happy to try and answer them.
Any questions? Next, please.
Report on administrative leave.
Mr. Doyle.
Mr. Chair, members of the Commission, this is a quarterly report that we do on administrative leave, and this is something that the Commission had requested last year at some point, just to be kept appraised of those a number of positions that are on administrative leave at the current time. I think in the last few reports we've always hovered around 3, 4, 5 employees. Typically it's different people. As people are coming off, others are being put on. But in this case we have 2 from Police Department, 1 from Glendale Water Power, 1 from Finance, and 1 from Public Works. As I've said to you in previous times for this report, this is something we do look at closely. The decision to place somebody on administrative leave is one that's taken very, very seriously, very cautiously, and I want to assure the Commission that even though these employees are not at work in a productive capacity, the reasons for them being on administrative leave are appropriate. I believe it's in the best interest of the city to have them in this capacity until these matters are resolved. So if you have questions, be happy to try and answer them for you.
Any questions?
I have one question. Are we to assume that it's due to disciplinary matters that they're on these leaves, or medical issues pending, or?
Mr. Chair, Commissioner Hatamian, there are typically two, I would say 3 circumstances where an employee would be placed on administrative leave with pay. One would be that they are under investigation. So you can say a disciplinary circumstance, yes. The second instance would be if someone is facing discipline, someone has been served with a due process Skelly letter where, for example, they're being recommended for termination. In those cases, we're not going to want to have them in the organization until that matter is resolved. And the third would be a consideration of a medical type situation where someone is being examined or evaluated for either their physical or mental capacity to remain on the job. And I again, given the confidentiality of it, I couldn't really give you any further details on any of these, but in general, those are the reasons we would place someone on admin leave.
And does the Department of Human Resources monitor the disciplinary matters to ensure that, for example, if we have a disciplinary matter pending with Glendale Water and Power, to ensure that the investigation gets done as quickly as possible and an intent letter is served so we can take the employee off of paid leave? Because at the end of the day, we want to save the city as much as we can.
Commissioner Hatamian, yes. I personally am very much engaged in all of these activities. And again, these are at various stages. Some are at the investigation stage. Some are at the stage where they've been served with discipline, if that's appropriate. Some have received the proposed notice of discipline and are awaiting a Skelly hearing with the city manager or the department head. As you recall, when this item first came up, I gave a rather extensive explanation for all of the steps along the way, and I think hopefully was able to enlighten everyone as to why these matters do drag on for very long, regrettably. But to assure you, Commissioner Hatami and myself, members of my staff are very much engaged in all of these situations, and our objective is to get through them as quickly but thoroughly as possible.
Thank you, Mr. Doyle.
Okay, I think we need to step back for a minute.
Let's review the previous item number 5. It was accidentally skipped. Eligible list established.
Mr. Doyle.
Mr. Chair, members of the Commission, this is a note and file item. We try to, again, keep you up to date on all the lists, eligibility lists that have been established from one meeting to the next. We're coming back from the sort of the Christmas holiday period, so there wasn't a lot of recruitment activity or examination activity, but we do have two lists that have been established since our last meeting. One is the Community Relations Coordinator, which was an open recruitment. You can see the over 300 applications for that. And the second one was a promotional recruitment in Public Works for motor sweeper operator. You sort of see the contrast between open recruitments and promotional recruitments, given the number of candidates we have. And I'm happy to say following the establishment of this list for a community relations coordinator, we have made an appointment for that position, and the individual started just this week. So, again, if you have questions, be happy to try and answer them for you.
Any questions? None. Also, we did skip over the oral communications. Is there anybody in the audience that wishes to address the commission on items not on the agenda? Seeing none, we'll move on to the next item, please.
Public hearing, adoption of resolution, 12-month probationary period classifications.
Mr. Doyle.
Mr. Chair, members of the commission, we're about to present two separate resolutions that we bring back periodically. These are somewhat routine, but we try to do them on an annual basis. The first one has to do with the designation or declaration of job classifications throughout the city that carry a 12-month probationary period. The second one has to do with the declaration of unclassified positions. I'll start with the first classification, or the first one, which involves the 12-month probationary period classifications. Most of the positions within the city carry a 6-month probationary period, but there are a sizable number of positions classifications that we believe are so important that they would warrant a full 1-year probationary period. As you know, when one is on the probationary period, they are considered at will. They can be removed for any lawful reason without any type of appeals or property interest rights or protections thereof. What you see here is, again, a rather extensive list of all the positions that have been declared, traditionally been declared to have a 12-month probationary period. Again, probably 95% of these are managerial and mid-management and executive level positions. The other exceptions to that in the non-management ranks are those primarily in the public safety arena, non-sworn as well. You'll see both positions such as police officer, police sergeant, even though it's non-management, would carry a 1-year probationary period. Our community service officer positions in the police department carry a 1-year probationary period. Our fire communication operators, our dispatchers, these are very challenging positions. They require background investigations and such. And again, we place them in a 12-month probation. So with that, Mr. Chair, if you have questions, I'd be happy to try and answer them. Again, as we establish new positions and change our salary structure and our benefit salary resolution, we try to make sure we include all the new titles into this report, and we do this periodically. So with that, it does require public hearing and vote of the commission. So.
Okay, with that, I will open it up for public hearing. Is there anyone that wishes to address the commission on this item? Seeing none, the public hearing is closed, and I'll turn and see if there's any comments from the commissioners.
I have a question.
Mr. Gazarian.
Fellow commissioners, Mr. Chair, Mr. Doyle, I looked at this. I recall last year, went through this, and there was at the time park ranger position, which was no longer there. This time around, it's perhaps part ignorance, if nothing else. I ask for the following. Do we have the following 4 positions currently to necessitate the need for them to be in here? One is assistant city clerk. The other one is assistant fire chief. The third one is assistant police chief, which I don't think we do currently. And the fourth one is chief assistant city attorney. If you can enlighten us as to those 4 classifications.
Commissioner Gazarian, we do in fact have an assistant city clerk. That is Miss Rita Buchanan.
Okay.
Assistant fire chief, that position is currently not being utilized, but it still remains in our classification plan in case the current chief or the next chief decides they want an assistant. But the highest position next to the chief in the fire department is deputy chief. That's Chief Doyle. No relation.
Okay.
Sure.
Your third question had to do with the assistant police chief, and no, the current structure currently does not utilize an assistant police chief.
But we had one before.
But we keep it.
Correct.
Okay.
It's in. Chief DePompa made reference to bringing that concept back, and we're looking at either possibly utilizing this classification, or we might want to do it in a different manner where it's an appointed position versus and rotated versus an actual civil service position, but that's still under discussion. And the fourth question you had, the chief assistant city attorney, that is currently being utilized. That's Ms. Jillian Ben Meiden is our chief. In fact, she was appointed to that in the last 6 months.
That's what I was trying to recall. Yeah. Okay. Thank you.
Sure.
Any other comments?
Motion.
I have one question for Mr. Doyle. Would this, if we adopt this, would this retroactively change any employee's probationary period that was hired, let's say for a 6-month probationary period, and our approval would make it 12 months?
That's a good question, Commissioners. It's a hard question to answer, but it doesn't happen to be the case of any. There haven't been any positions that have been added to this that would affect anyone who's been recently appointed in the last year. Like Commissioner Kazarian asked about the chief assistant city attorney. Well, yes, in the last 6 months she was appointed to this position, but it had previously been on this list as a 12-month probation. So there aren't any cases of that I'm aware of where one was 6 and just recently got changed up. What we try to do is, as new titles are established and adopted by the council, is to make sure those get included on this report.
Thank you.
Second, Mr. Gantis's.
Second. We have unanimous consent?
Yes.
Next item, please.
Public hearing, adoption of resolution, unclassified hourly classifications and positions.
Mr. Doyle.
Mr. Chair, members of the Commission, again, this is another report which we try to bring back to you on an annual basis. You're familiar with the concept of classified and unclassified positions, and this is a report that just addresses all of our hourly classifications, and to reaffirm that they are unclassified at-will positions. Periodically, we will bring to you a report on a similar fashion, a public hearing of our salaried positions that we put forth as being unclassified. That's not included here tonight, and that's not contained here. Typically, those positions would be ones that we hire for a temporary period of time where we may have some grant funding which might run out after a certain point, and in those circumstances we'd want to make that position unclassified, enabling us to lay that individual off without granting them property interest rights or anything like that. This item before you tonight, these are essentially the part-time job classifications, and this resolution affirms the fact that they are unclassified at-will positions. Again, they are all listed here on the report and under item number 1. Item number 2 on the actual resolution makes that declaration that all hourly positions assigned to permanent civil service classifications are also declared unclassified. So, for example, if we were to take a position of a assistant engineering technician and hire someone on a part-time basis and pay them on an hourly basis, that individual, even though they carry a full-time salaried title, that would still be considered an unclassified position. So, with that, Mr. Chair.
Okay, we need to open up the public hearing. Anybody wish to address the Commission on this item? Seeing none, we'll close the public hearing and ask for comments.
Move to approve.
Second. Do we have unanimous consent? Unanimous consent. Next item, please.
Report on proposed charter amendments to civil service rules and regulations.
And we'll turn to our Assistant City Attorney, Lucy Barpetian, Senior Assistant.
Thank you. This is an item that was before the City Council in consideration of charter amendments. There were a number of items that the City Council was considering amending. A few of those items related to the civil service rules. While we have passed the deadline by which time we can place these items for the April 2013 ballot, the direction from the City Council was to continue to meet and confer with the employee associations for placement on a future ballot, and that may be in the form of a special election, or it could potentially wait to the April 2015 election. There were 4 items that were identified by staff that related to the civil service rules, and we've outlined them here. If it would please the Commission, I'd like to give you a general explanation of what each of those were.
Please.
The first had to do with bumping rights, and what bumping requires is that if a position is eliminated, usually in the event of a layoff, then an individual who has seniority in a particular classification has the ability to bump and bump out someone with less seniority, and then ultimately potentially bump down to a former position that the individual held. This is not limited within a specific department. It could be cross-departmentally, which means that an individual with very specific duties, say in the finance department, could ultimately be bumped to the police department and serve as a crime analyst without having the requisite qualifications, even though they may hold the same title. The proposal in this instance was to amend the rules and allow that to be addressed in the civil service rules. So the idea of bumping would not be eliminated, but that it would be before this commission, and the commission would have an opportunity to comment on what the rule relative to bumping should state. The next item had to do with the rule of 3. This requires that in the event of a new hire or promotional hire, that the appointing authority be provided the names of the top 3 ranking individuals to the appointing authority. There are a number of different other options that are available within the civil service rules. They go anywhere from rule of the list to banding. What these different rules would do is they would provide the appointing authority a greater number of individuals to select from. So it would not be only the top 3, but it would be maybe a top percentage, which would provide the appointing authority a greater option. As it relates to this particular item, the city manager's recommendation was that the charter be amended to allow the commission to establish the rules providing for more flexibility pertaining to the ranking of candidates. Again, this would take the restrictions from the charter and place them in the rules and make amending them as time changes a little bit easier. The next item had to do with budgetary reallocation of a position. As you know, that the City Council has the authority to reallocate an existing position, but what that means is that once they've done that, the Human Resources Department has to go through an entire recruitment process, and that creates redundancy. It creates confusion in the process. The rules currently allow for suspension of competition under certain circumstances. What we would be doing is adding this particular situation to that, so that competition could be suspended in the event that the City Council determines for budgetary reasons to reallocate a position to something else. The last one that was identified by staff and presented to Council had to do with the timing of the civil service appeals. What Article 24, Section 9 currently requires is that the Commission commence a proceeding to hear fully and determine the matter within 2 weeks after filing of an appeal. As you know, over the years, these appeals have become a lot more complex. the number of the witnesses, the amount of evidence that needs to be reviewed, the juggling of calendars for council makes it difficult to not just initiate the hearing, but also to hear the matter fully and come to a determination. What this amendment is proposing is to allow the Commission to do it within a reasonable time and not within the stringent 2 weeks that are required by the Charter. Each of the 4 items that we've identified are subject to the meet and confer requirements of the Myers-Milius and Brown Act. What that means is that we are required to meet with the employee associations and discuss with them what are being proposed, take their comments, and ultimately meet and confer with them as to what the proposed amendments are. We have initiated that process. We've gotten, I think, at least 2 meetings with most of the associations. There are 5 of them. And we do still have some more work to do with them. So over the coming few months, I think we would be able to do that. But we wanted to bring this to the Commission because we wanted to hear your comments as it related to this. And I understand that there was one additional amendment that was being proposed by a commissioner, and we can certainly have a discussion about whether or not there is a concurrence on the part of the Commission to present that to the City Council as an additional amendment to the civil service rules. We can discuss what that is, and that has to do with Charter Article 24, Section 9 again, and what that requires is that a matter that is before the Commission has the ability to review or to hear an appeal either as a collective body with all 5 commissioners meeting together, asked an authorized representative to hear a matter and bring back a recommendation, which is then approved by the Commission. And then there is a third method which allows a subset of the Commission to review it. And in the past, that's been either 1 commissioner, 2 commissioners, or as many as 3 commissioners who've reviewed an item and then brought back a recommendation to the full Commission for review and final determination. The recommendation is that in those instances where you have a minimum of 3 commissioners hearing a matter, then if they reach a unanimous decision, then their decision be a final decision of that item and not have it come back to the full Commission for additional review. I can tell you that as it relates to that particular item, we've had very brief discussions with at least one of the associations, and they were not in support of it. I know that in discussions with the city attorney, he also did not support that position, mostly because our view is that it is a core function of this Commission to hear disciplinary matters, in that even though you have a full concurrence with the 3 commissioners, there's unanimous in the likelihood that the determination will change when it's brought to 5 commissioners versus the 3, that the weighing in of the 2 additional commissioners is a significant role that they play, in that it should come back to the full Commission. But that is something that the Commission can discuss, and if it is your position collectively that you'd like for us to take to the Council, we can certainly do that.
Okay. Well, any comments on the presentation that Ms. Varpetian made?
I have a question. Basically, the last portion of you just described to us, that new proposition, if I understand correctly, the only portion of that proposition is different than what the Charter currently said, is that the 3 people that hear the case basically make the decision without bringing it back to the full Commission. Is that the only thing different?
Only that the other provision is that they must have unanimous decision, so that there has to be, if you have a subset of the commission, 3 commissioners hearing a matter, and it's a 3-0 vote, all 3 commissioners agree, what's being proposed is that it is an additional drain on the resources, where you have to bring that back to the full commission, have the 2 additional commissioners review the matter, have staff prepare reports, in that maybe it's not a worthwhile endeavor, considering the 3 individuals have already agreed, and the likelihood that the vote will be different at the end of that is minimal.
At least I can speak for myself. The one issue that I have with that, there's been times that I've sat as a member of a panel on a particular case, and I have voted a certain way. And then when it comes back to the full commission, the other 2 commissioners that weren't on the hearing brought up suggestions that I did not think about, or brought up issues that I didn't take into consideration. And I have found myself sometimes to vote differently after that deliberation is done. Because I get the benefit of hearing another person's take on it. That's, for me, that's the opportunity that I would lose. But I'd be curious to see what my fellow commissioners would think about that.
Mr. Gaddis.
Well, I couldn't have said it better myself, Mr. Manukian. I don't know that I've ever complimented you in that regard. I can envision a time when I might be on a panel, and as omniscient as I am, and Mr. Gazarian, for instance, is not. I actually look forward to his input. I may not agree with it, but I look forward to his input, and so I tend to agree with you, and also with the, as you've indicated, with the complexity of these hearings, as we've seen in item number 4 that we talked about, and the fact that they are now growing into really large proportion. I think that's a core function that needs to stay with the whole commission.
Mr. Hatamian, do you have a comment on that?
I mean, we've had cases where, we've had a panel of 3 commissioners hear a case, and then all 5 collectively come together. I mean, the disadvantage is that the 2 who were not present during the hearing aren't able to see the witnesses testify, aren't able to see the truthfulness, and or if sometimes we have witnesses who may be deceitful, we don't get to see that information, which 80% of communication sometimes is done non-verbally. So we lack that information that the other 3 commissioners may have. In addition to that, we're not part of the fact-finding process. So whenever there's questions as to the admissibility of evidence, we don't get to weigh in, whereas you have 3 other commissioners who were present and they were able to weigh into that information. So it creates this, dynamic situation during deliberations amongst commissioners who were not present and don't have that information. Yes, we can read information in writing and we can look at, the reports that come out and the transcripts, but at the same time, again, we lack that nonverbal communication, things that go on during hearings. So my opinion is, ultimately, I think it creates this burden on the 2 commissioners who were not present to kind of, and I don't want to say go along with the 3 remaining commissioners who were present, but we kind of have to buy into what they have to say about the witness's testimony because we weren't there.
How do we fix that? And I have the same concerns. I agree with you.
I think the problem isn't just this, isn't Section 9. I was going to start off by talking about D, which is the civil service appeals. I think the problem is, the load of work that the commission gets and the tier of review that we have ultimately. Having been familiar with the other forms of commissions that are in Southern California and actually working in that system, I can say that no 5-panel commissioner sits there and hears a hearing. The way it works is that you have a hearing officer that will hear the hearing, they'll make a finding, and then the commission will review that finding, and all 5 will make that decision. And that creates another level of review. So my issue is mainly with D. I think if we address what D is, D, what it's trying to say on its face is that it's going to give authority to the commission to say that we are going to hear an employee's case within a reasonable time. As a commission, the issue isn't just accommodating management and our employees. As neutral fact finders, we have to understand that we have employees sometimes that will file appeals and they could be on a waiting list for a reasonable amount of time. Well, what is reasonable? What if we do get clogged up with a lot of cases and we have an employee without pay sitting at home? You guys know as well as I do, we've had employees that have been brought back. So why place that burden on them? Okay, so on its face, it's giving us authority to hear cases within a reasonable time. But we also know that as commissioners, we have the ability to assign cases if need be, if we are overwhelmed with the caseload, and that way we accommodate the employees who may have been discharged for an unreasonable reason, and they come back to work for whatever reason. So, with back pay sometimes, exactly. So my issue doesn't start with Section 9, it's just a precursor. I think if you look at D, and I don't want to switch our discussion from Section 9 to D, but if you look at D and we make a ruling and or a recommendation to council to take back to city council, and I guess the way it would have to be worded is now it's a 2-week period if I'm not mistaken, right?
But have we always accommodated that 2-week? I mean, I remember...
One of the things, what our current practice is to commence it within the initial 2 weeks. And what we were going to do, one of the comments that we'd received, again, from the associations, was to have the charter reflect that we commence the hearing within the initial 2 weeks and then hear it within a reasonable time. And in that way, the employee is ensured that their attorney is present, and that they are participating in the scheduling of the process, and so at least they've got an advocate on their behalf who's concerned about the length of time that an employee may be home awaiting a determination. So that was the compromise that I think we were going to reach. We haven't drafted that language yet to see what it would look like, but that's the concept. The current practice is to commence it within 2 weeks and then hear it within a reasonable time. In that what is being proposed here be more specific to maintain that it commence within 2 weeks.
Commissioner Atami, does that address your concern?
Ultimately, I mean, if we're going to say we're going to start off a hearing within 2 weeks, and then have a language that says, well, we have the authority to do it within a reasonable amount of time, is that discretion upon the commission to hear that case? And if we do get overwhelmed with cases, where does that leave the employee? It's one thing to think of it from the management's perspective. It's another thing to think of it from the commission's perspective. And then once we switch hats and look at it from the employee's perspective, we want to be able to hear these cases as quickly as we can. But sometimes these cases go on for days, and we sit in hearing. A system in which, and again, correct me if I'm wrong, Ms. Barpetian, a system in which we have hearing officers to go to where we are overwhelmed will accommodate the employees, will accommodate the commission.
The option is there, isn't it, right now? We do have that option.
The charter does currently allow an authorized representative to hear the case, and we've made the determination that could also mean the authorized representative could be a subset of this commission. So it could either be an outside hearing officer, or it could be a single commissioner, or a different makeup of the entire commission. But ultimately, the determination must be made by the full commission. So while it might go out to an outside hearing officer, it has to come back by way of a recommendation to the full commission.
Okay. And so I guess my concern is, and or I ask Ms. Barpetian for your input, if we have a hearing officer who's going to hear a case and they make a finding, and then we have the commission that's going to review that finding, and which it creates another tier of review. So for the purposes of when you have an employee and or management who's unsatisfied with the findings of the commission, and let's say they file a writ, that enables the city to say, well, we have several layers of review. In addition to that, it creates this thing where we don't have two commissioners that weren't in on a hearing to make a decision where they weren't present. Everybody makes a decision based on moving documents. everybody makes a decision based on written findings of a hearing officer. Whereas in this case, now we have it where you have three commissioners that will sit in, hear the case, and then we'll have two other commissioners that will come in and kind of get the feedback from the commissioners who were present. So what would be your take on that?
I don't have a take on it. I can tell you what the charter requires. I don't think from management's perspective there has been a concern about the way that the commission has held the meetings has held a subset of the commission to review matters and then bring it back. Ultimately, the responsibility is on each commissioner to review all of the evidence, review all of the testimony, and deliberate and reach an informed decision independently as part of the deliberative process. Each commissioner has to be able to rely on his senses to reach a conclusion. That has been our practice, and I'm not in a position to state whether or not it's good, bad, or should be different.
And I agree with you, and that's noted. And I think that all the commissioners sitting here understand their task as far as hearing the cases and making a decision based on their own input. I guess my thing is, what is your take from a legal perspective of having another tier of review? Would that be beneficial for the city if our decisions are appealed in the Superior Court to have another tier of review, which would be a hearing officer?
I don't think we would see a difference in that. It's not a different tier, but it's a recommendation that comes back, and there's the commission's determination is the final ruling. So I don't think that while you've got a separate person who's doing the review, that is certainly allowed in the charter. It doesn't make the matter more bulletproof, so to speak. It doesn't make it any different than or better than the way that we have it now.
If I may.
Okay, Mr. Guzarian.
Thank you. I struggled with some of the issues that Commissioner Hatamian has addressed for some time, but I reached a place which is largely based on a remark made by Commissioner Manoukian moments ago. When three hearing officers, who are really essentially three commissioners in a subset setting, sit and hear a matter from beginning to end, that's three hearing officers as opposed to this concept of an outside one-person hearing officer, if you will. So in many respects, it provides the litigants three judges of facts, if you will, as opposed to one. Yet it provides that additional tier that you appear to want to provide, which is something that I agree with, that additional tier. That additional tier is then provided in the setting of the entire commission, where, lo and behold, perhaps a fact finder in a subset commission hearing setting is persuaded by the other two who are overseeing, along with the other three, all over again, fresh, the facts that were presented at the hearing, and reach a decision. So for that reason primarily, I would say that, at least I can speak for myself as a commissioner in this city, I would like and welcome the opportunity and the added burden from time to time, as the chair determines, to sit on those hearing panels as a hearing officer, along with fellow commissioners, and then to engage in the process yet again with the others, one or two who were not part of it. And I think it provides, in the final analysis, the overall best and most complete means of litigating the merits of each party that appears before the commission. So with that, I urge you to think of it a bit longer. I did for some months when I initially joined the commission. I'm very satisfied with the situation as it is now, whereas I wasn't a few months ago, and I believe Ms. Varbetian can attest to that. Thank you.
Okay, and I was a strong proponent for the first decision or first comment that Ms. Varbetian made about changing the process to with a three-panel member, three members that reach a unanimous vote, that's where it ends. It does not go back to the full commission. And I've been thinking that for a long time since I've been on this commission because of the experiences I've had in the many hearings. But I have to concur with Mr. Kazarian that tonight Mr. Manoukian changed my mind. He brought up a point that I thought was very relevant, and because of that, I've changed my position on this. I think that your analysis about having the two other people, even though they may not have sat in on the hearings, they may have a different perspective which could influence my initial decision. I think that's very important, and I appreciate your comment on that. And because of that, I too would be satisfied leaving it as it is. So with that, that becomes a moot point. We won't be bringing that back. I'll ask the commissioners if they have any comments or want any discussion on the 4 points that Ms. Arpetian brought up on the initial items. Mr. Gantis.
I just want to, two things. I do have one, but I want to tell Mr. Manoukian, just remember, Mr. Manoukian, a blind squirrel does find nuts every once in a while. With respect to item D, I would say from this commissioner's standpoint that the idea of commencing within 2 weeks rather than a reasonable time would be, I think, appropriate and state what we do and and address, I believe, Mr. Hatamian's concern about the employee. Somebody said it, they get their person in front of us within 2 weeks and they can control the setting of the hearing. So that I would agree with that.
Do you need any other direction from the commission?
I don't on the items that were proposed, but you can find the civil service section under Article 24 of the Charter. If you'd like a copy of the Charter, I can certainly provide it to you. It's available online. If you'd like to review it and you see anything else that you think should be brought to our attention, we certainly have the time now, since we're not aiming for the April 2013 election. We will take your comments and present them to the council if there's a direction from the commission to do so.
Okay.
Mr. Chair.
Yes, Mr. Doyle.
I wanted to thank you for your input on this. This is, to some degree, a moot point, at least for the time being. Our initial thought was to try and get something on the April ballot, but given the meet and confer obligations and truly, attempting to find some consensus amongst our 5 very diverse employee groups, that was not going to be possible. There will be some amendments to the charter, which will be appearing on the April ballot, mostly having to do with financial and purchasing issues, as well as the appointment of the city treasurer. But we will continue to look at this, and I will say that the meet and confer process with our employee associations was quite helpful. We were able to meet several times with some of our groups. Some we were not, but we were able to get some really good input and ideas from those groups that were met with, and found the whole thing to be very productive. So we hope to bring this back, albeit not as condensed a time frame, but this issue will not be going away.
Okay. Next item.
Agenda forecast.
Mr. Doyle.
Chair, members of the Commission, the agenda forecast is before you. The January 23rd meeting, which is our next scheduled meeting, we do anticipate having a presentation from the Verdugo Fire Communications Center staff, as was requested at, I think, the previous meeting. We'll also have our routine quarterly advertising budget report, and that'll be it. As you know, the Commission continues to be very busy with the hearings. So,
I have.
Yes, Mr.
I have 2 dates on this forecast that I need to address.
Okay.
One is February 13th. I will be absent. I'll be out of the country. The other one, April 24th, I will not be present. That is Armenian Genocide Commemoration Day. I don't know if my other colleagues of Armenian ancestry will or will not, but you ought to take note of that.
I won't be present as well on the 24th.
You will not?
Will not.
So let's make a executive decision to cancel the meeting on the 24th.
In all likelihood, I will not be present either, because there's usually a commemorative event that many of us go to.
Okay.
So.
Also, Mr. Gantis has told me he will not be here on the 27th. And I will not be here. I'm sorry, he won't be here on February 27th.
Commissioner Gantis will not be here on February 27th.
I will not.
And Mr. Devine will not be here on March 27th. Any other comments on the calendar? Seeing none, we'll move on to the next.
Oh, I do. I'm sorry. I apologize. Are we having actually the staff from the Verdugo Fire Communications Center going to be here?
We will have some.
Some.
Certainly, we'll have the chief as well as the executive administrator, Mr. Wise, and I believe we'll have a couple representatives of the staff there.
And the only reason I say that, this is a positive in my mind because we're hearing so many negatives coming out of the county of Los Angeles and city that I think ours is something to be.
It's been a true success story.
Yeah,
all
I
the
think
way
it
around.
needs to be heard.
Okay. We'll let the record show that Commissioners Mnuchin and Gazarian had to leave at this point, and we'll go on to the next item, please.
Reports, past due employee performance evaluation.
Mr. Gaddis, would you handle that for us?
Yes, I can. I see we're moving down the list of numbers that are on no past dues. We have the city manager's office, we have the city treasurer's office, we have the police, and we have public works. We have no third notices, 14 second notices, and 22 first notices out of, I think we're still at, 1,550 or 1,600 employees. So
1,600 employees.
it's still pretty good, but we have a lot of outstanding ones of some of these departments. I assume they'll get the hint and do a little better.
Sir.
Okay, thank you. Next item.
Civil Service Commission, staff comments.
Any comments from commissioners? Staff? Hearing none. Next item.
Closed session, none.
Next item.
Move to adjourn.
Adjourn.
We are adjourned.